Hi, my name is William Mays, and I'm a Michigan criminal defense attorney. And today I'd like to talk to you about how a drunk driving can affect a CDL in Michigan. As a CDL motorist, of course, you really can't afford to ever drink and drive, but I get a number of people who have CDLs that call my office asking for help. Now, normally this is in a non-commercial vehicle. This is not while the person's working, but unfortunately, years ago, Michigan combined the commercial license and the non-commercial license, and now I can't even remember how long ago that was, but nowadays, if you get a drunk driving and you're convicted of either OWI or the lesser included offense of operating while visibly impaired, you're going to lose your CDL for 1 year. At the end of that year, you can take the written and the practical examination again and get your CDL back, but that doesn't help you after a long career as a commercial truck driver. Let's first talk about what the requirements are for you while you're operating a commercial vehicle. Michigan law says that a person may not operate a commercial vehicle at .04 or greater. So half the legal limit is illegal for a commercial truck driver while operating a commercial vehicle. That does not mean that you are over the legal limit if you're operating your passenger vehicle, your non-commercial vehicle. There, the law is .08, or operating while visibly impaired, which doesn't really have a set BAC level for it. But while operating a commercial vehicle, the law says .04. Now, that's a little bit misleading, however, because federal regulations indicate that a motorist may be taken out of service if he or she is operating a commercial vehicle in excess of .02, or, and this is even more vagueness, if the motorist is visibly impaired, leaving it up to the motor carrier officer to decide whether or not to take the person out of service. So a couple of years ago, I had a commercial truck driver who was stopped, hadn't had a drink in days, maybe as much as a week, and the trooper asked him to submit to a PBT, and of course he agreed because he hadn't been drinking. Blew a .002. Now, I don't know what this trooper was thinking, but took the motorist or took the CDL driver out of service, issued tickets, and listed it on the federal database for commercial truck drivers. This led to a nightmare. And this was not the driver's fault at all. Again, the driver had not consumed any alcohol for days and days and days. This was, basically the preliminary breath test was measuring either noise or sugar alcohols for gum or any number of other reasons why a person might blow a .002, which is less than what's capable of being measured by the Data Master, the Michigan State Evidential Breath Testing Device. A roadside breath test should never be used for something so serious as this, but sure enough, you'll get the occasional officer that does this. We'll talk about that in a few moments. Now, Michigan law says that if you're operating a passenger vehicle, you can't be .08 or greater or visibly impaired. As I indicated earlier, if you're convicted of that, then you lose your CDL for at least 1 year, taking the written and practicals at the end of that year and getting your CDL back. There is, however, a way to save your CDL. And that, of course, well, one, easy enough, you take it to trial and you win the charge. Or you file motions through your attorney and you get the charges dismissed. But recently it came to my attention that if you get a reckless driving, it does not cancel your CDL. This was verified through the Secretary of State CDL hotline just the other day. If you get a reckless driving, then the 90-day hard suspension applies, just as it would for any non-commercial driver. So 90 days, no driving whatsoever. Passenger vehicle or commercial vehicle, no driving for 3 months. However, many employers will be willing to work around that. So that is a possibility, that if you get your charges reduced down to a reckless driving, that you can save your CDL. Of course, if you can get a careless driving or a disorderly conduct or something like that, that would be even better, but that's very unlikely given how prosecutors across the state treat drunk driving offenses. Now, let's say that you're in a situation where you've either beaten a drunk driving charge or had it reduced down to a reckless or a careless or a disorderly conduct, whatever the case might be. What are you going to want to do about that to make sure that you're still legal to drive and that there aren't any problems? The federal government has set up the Federal Motor Carrier Safety Administration has set up a computer database, and this has been around for at least a decade, maybe longer, that they collect all information from the various states. States report it, and the federal government logs it into this database that allows them to track commercial motorists from state to state. And unfortunately, there's a lot of problems with the system. And as a result, the federal government has set up DataQ. DataQ is an opportunity for a commercial motorist to make a request to correct the data. And you can go on, as long as you've got an account, you can log on to this system and try to correct mistakes that are made in the system. So, there's been some developments on that in 2014. In February of 2014, there was a case, Weaver versus the Federal Motor Carrier Safety Administration, that went to the Court of Appeals as an original action because an adverse decision, I believe it came out of Montana, was given by an officer from Montana. Now, in that case, the truck driver or the trucking company had challenged a ticket in the court, and they'd beaten it, but it was still logged into the database. And they were under the impression that it wasn't going to be entered into the database. But when they contacted the officer told them, oh no, it's going to go into the database. What do you do in that situation? Well, normally, historically, you'd contact the officer's department. Now, in my case that I handled, sure enough, we contacted the Michigan State Police, and Michigan State Police would not offer us any assistance whatsoever. They were going to stick to their guns and protect this trooper who had made this boneheaded decision out on the road and say, well, it's up to the officer's discretion. It's not completely up to the officer's discretion. But if there's no effective forum in which to challenge that, where do you turn to? There's good news on that. Out of this Weaver decision, which basically accomplished nothing because the court determined that as a matter of jurisdiction that they did not have jurisdiction, and that's more for the lawyers to contemplate and to analyze that case. But for your purposes as a commercial driver, this led to some changes in the way that the federal government has set up the DataQ system. Now, as of August 25th, 2014, if you've been able to successfully challenge a ticket in state court, you're now permitted to submit that paperwork in connection with your request to correct the data, and that will be taken into account by the federal government in terms of removing it from the record, which that's an important step in the right direction because previously they weren't doing that. They would simply turn to the state government and ask the state or local authorities, what's your position on this? And they would do whatever the federal state or local authorities were telling them to do, which led to no correction whatsoever if you had a pig-headed officer who was refusing to correct an error that they had made. The only other alternative that I could think of to that was suing the officer for defamation in state court or bringing some sort of a constitutional claim in federal court against the officer or the department. And those really aren't viable options in most cases because damages are limited and attorneys are expensive and civil litigation is expensive. But in any event, the good news is that the DataQ has been revised as just a couple of weeks ago. At least there's some updates to it so that this system should be working better in the future. The other thing that you're going to want to check out is your DAC report. A DAC report is not the same as the federal reports. This is it's a private report that's handled between trucking companies. They can order your DAC report and see what's on that record. Now, a DAC report is covered by the Fair Credit Reporting Act, much like your credit ranking and that sort of thing. You're entitled to a free copy of that once every year. And so if you've recently gotten through a charge, you should wait a little while, see what comes up on any sort of employer radar or whatnot, but then order a copy of your DAC report. And you can do that by going to hireright.com online. It's HIRERIGHT. And you can get a free copy of that report once per year. If there's anything else that I can help you with, feel free to give me a call. My telephone number is toll-free, 888-941-1122. you can also look at my other information that's available on my webpage, Michigan-drunk-driving.com. I'm William Mays, and thanks again for listening.